The chair lays out Senate Bill 2794 and recognizes Representative Dutton.
Thank you, Mr. Chairman and members. It was surprising to me, but the current law on interference with child custody only applies to the non-custodial parent. Did you know that? I didn't either. I had no idea that's the way the statute was structured. And so how Senate Bill 2794 does is changes that so that it applies both to the non-custodial parent and the custodial parent as well. And so that's essentially all it does. It creates also a 3 strikes policy where under the current statute, a non-custodial parent, however, could be jailed, be sentenced to a state jail felony for interfering with child custody. And what this bill does is simply says that we're going to make it a 3 strikes rule for both custodial and non-custodial parents. That's essentially all it does, Mr. Chairman and members. I'll be happy to answer any questions.
Okay. Any questions for Mr. Dutton? Not, we'll give you the right to close.
Thank you, Mr. Chairman.
Chair calls Rod McCall. And Mr. McCall, your affirmation shows that you're here testifying on behalf of yourself and that you are for the bill, correct?
That is correct. I'm a little flustered. I apologize. I wasn't expecting you to get called so quickly. I have been a school teacher. I am a licensed professional counselor, and I'm also been divorced. And the idea that a parent can mess with custody is kind of a big problem. Most times, mom and dad, when they get divorced, they can put their anger and hostility off to the side. But sadly, that's not the case all the time. And in this particular case, I like this bill because it puts teeth into that is already on the books, that if mom or dad messes with visitation, that it gives law enforcement and district attorneys the opportunity to increase the punishment rather than go straight to jail time. And as a result, like I said, I was going through my divorce. This was an occurrence that happened more times than I wish it did. I've seen this happen for many other individuals, and the children that I work with, it happens as well with them. So I like the idea that the increasing of punishment so that way, kids have an opportunity to have a relationship with both parents. As a friend of mine likes to say, divorce is to end the marriage, it is not to end the family. Thank you.
Thank you, Mr. McCall, for being here. Let me see if there's any questions. Thanks for being here. Chair calls Bella Rockman. Ms. Rockman, it shows that you are a neuropsychotherapist, and here testifying on behalf of and you're neutral on the bill, correct?
Yes, sir.
Okay.
Good morning. Thank you, Chair Smithy, and thank you to the committee for taking a moment to listen. I'm Bella Rockman, and I work as a licensed clinical neuropsychotherapist, and I also work as a media mental health care commentator. And I'm here today on behalf of Bill 2794. Unfortunately, all parents don't always act in the best interest of children and with maturity and social and emotional intelligence after custody orders are decided. And this is not a gender issue. I think this is gender neutral. This can happen with either dads or moms. And unfortunately, sometimes children are weaponized, and custody orders are used to weaponize to do something called post-separation abuse, which is sort of a retaliatory approach against another parent as sort of a punishment or a way to continue to control and create disruption. The Center for Disease Control tells us that when trauma happens, more important than the trauma itself, it's how it's responded to in the aftermath. And I think that we have an opportunity here with this bill to add an exception to the bill to help to protect parents that might be in a situation where they're actually avoiding or fleeing family violence or domestic violence for safety. So adding that exception, I think, would help to strengthen the efficacy of the bill and help to provide support for families and children that have experienced trauma already, but providing more clarity. Also, the San Antonio Police Department, for example, says that there's about 1,000 calls a month that come in around custody interference issues. So I think that adding an exception to this and moving the bill forward would also be helpful because it can allow our law enforcement agents to focus on what they do best in protecting our communities. And sometimes in the presence of clarity, it helps to eliminate confusion. Okay, that's So I also want to say that I do also unfortunately have personal experience with this. In my own post-divorce situation, there were over over 24 custody interference reports and calls that were made, and a bill like this, with the exception, could have added a great value and support. Thank you for listening, and if you have any questions, I'm
Well, thank you
available.
for being here. Any questions from, is it Dr. or Ms.?
No, Mrs., thank you.
Mrs. Rockman, thank you for being here. I need to recognize that Representative Bowers is present. Thank you. And the chair calls Jennifer Mudge. Ms. Mudge, your affirmation shows that you are here on behalf of the Texas Council on Family Violence, and you're neutral on the bill, correct?
Yes, that's correct. My name is Jen Mudge. I'm a public policy manager at the Texas Council on Family Violence. I'm here to testify on SB 2794. At TCFE, it's our practice to testify on a bill anytime we're attempting to work with the bill author to potentially change the language to better support victims. We really appreciate Senator Paxton, Representative Dutton's support of victims of sexual assault and family violence, and want to thank the staff at both offices for being responsive and solution-focused with the issues that we've raised. We absolutely understand the importance of parties following custody orders when children are safe. However, we have concerns about how the bill, as it's currently written, could unintentionally impact victims of family violence. Victims are the expert in their own experience, and as such, they're often able to recognize when violence and lethality factors are escalating before others can see these signs. As the risk increases, they often must make the difficult choice to flee their home to ensure their safety and that of their children. Fleeing is a stressful time and is known to be one of the most lethal times for a survivor. Therefore, it's imperative to their safety that victims are able to choose when and how they flee without the fear of criminal prosecution. As written, the bill does not currently contain an exception for cases of family violence, so our request is simple: to add that exception for survivors who are actively fleeing. Penal Code Section 2503 already has substantially similar language in place under C2 for cases where the child is taken out of the country. Should the committee recommend this bill move forward, we would just ask that the exception in 2503C2 be modified to include provisions under A and B. This would ensure that victims are not held criminally liable when they flee violence. Without an exception, victims would face the impossible choice of facing criminal charges when fleeing for their life, or staying in a home that they know is unsafe to avoid criminal charges. We're confident these suggestions will ensure the goals of the bill are still addressed while keeping victims and their families safe.
Thank you very
you.
much. Any questions for Ms. Mudge? Mr. Cook?
Just one question. Do you know if your organization or any other organization had made this request prior to this bill being filed?
I'm not sure. I don't know if we've had past work on that. I would have to look into that for you.
It just seems ironic to me that y'all are only bringing this concern forward now that this statute intends to apply to mother or father. So if this was a situation that was important to your organization or someone that was, in your shoes, it seems like y'all would have brought this forward prior to this bill being filed.
Yeah, I do know that we've had past work around custody statute, that we know that there's been that single piece in there that does cover attempting to flee violence. And I know that our organization has definitely prioritized having, the ability for survivors and victims to be able to flee as needed. So I can definitely look deeper into our work in that area.
Thank you.
Thank you, Ms. Jones?
Thank you for bringing up this very important issue. And as you've said before, you're absolutely the most likely to be murdered when you're trying to get out. And to have to, and sometimes you got to take the kids with you. And so I think that should be carved out. Thank you.
Thank you.
Anything else? Thank you, Ms. Mudge, for being here. Chair calls Sandra Aguilar. We'll note that Ms. Aguilar registered on behalf of herself for the bill but did not testify. Next, the chair calls Robert Garza. Mr. Garza, your affirmation shows that you're here on behalf of yourself and you are for the bill, correct?
Correct. Thank you for having me. My name is Robert Garza. This bill was born out of necessity after I drafted SB 718 last session with the support of Senator Paxton and Representative House Cook. It passed unanimously and was signed into law by the governor. When the false allegations stopped, my ex turned into interference with child custody. I took both the civil and criminal routes. That journey led me to this legislation. We would not need this bill if the current statute did not contain legal loopholes, but it does. And unless we provide clarity, prosecutors are left with nothing but grand jury bait because they cannot cases they cannot pursue because of vague and outdated language. This bill fixes that. It gives prosecutors the tools they need and law enforcement the authority to intervene. The three strikes model is structured, fair, and effective. It demonstrates a pattern of bad behavior while allowing parents the opportunity to correct it. It's not a state jail felony the first time, as it is now. Let me be clear, if you oppose the three strikes bill, you're against protective parents and do not understand it. By adding or subtracting any more language to this bill, it creates a space where you run contrary to the current family code. Another point to make, we are not addressing out-of-state or international cases. Those are already a state jail felony the first time that the parent interferes. So there's no need for that. There's already language in the bill. It complements the existing family code by reinforcing orders already issued by the court instead of making them go back to court to get more orders. This bill protects protective parents, it protects children from being caught in the middle, it respects both parents' bonds with their children, and restores the liberty to parents without interference, manipulation, or fear. This bill applies, well, it's
Okay,
it's
well,
pretty
thank you.
self-evident.
Any questions for Mr. Garza? Thank you for being here.
Thank you.
We have George Saldana. George Saldana here. And your affirmation shows that you are George Saldana here on behalf of Interference with Child Custody Group Texas and yourself, and you're neutral on the bill, correct?
Yes, sir. Can you give some copies?
Thanks, sir.
Do I start when
Go ahead,
when
yes,
you
sir.
finish? Okay. My name is George Saldana, and I'm going to go neutral on this bill. What I've given you is the Texas District and County Attorneys Association meeting we had here in Austin. Representative Richard Raymond set that up a few years ago, trying to go over interference with child custody. It's a state jail felony. We've met with DAs from across the state to have this enforced. Sorry, I'm out of breath. But as y'all know, this isn't getting enforced. I encourage you to talk to your DAs in your county to have this law enforced. Now, pertaining to the bill is going to amend the B portion of interference with child custody. The B portion talks about entice or persuade the child to leave the state. The issue we're having is on the A portion. The A portion is takes or retains the child in violation of a court order. So while I believe this is a good step moving forward, what we're doing is we're gonna, and I hate to use the word limit, but we're gonna kind of limit the felony to a misdemeanor when another parent entices or persuades the child to leave the state. If we can't enforce these court orders on the state level because DAs are not taking this charge under the A subsection, how are we going to enforce the B subsection with the enticement or persuasion of the child to leave the state? I don't know how many of y'all have ever done a UCCJEA motion or a petition, right, to obtain a child. Was that my time limit?
Well, you got about 20 seconds.
Okay, I'm sorry. So the enticement and the persuasion, you can't really entice or persuade a child to leave the state until you actually have obtained the child. So if it's there a retention or a taking or a retention, then it's kind of, I don't want to say useless to try to modify the B portion, but giving it a misdemeanor 500 civil charge, okay, you're lowering it down from a felony. The reason it's a felony is because you need federal law enforcement to travel outside the state to obtain the children and bring them back.
We've got, Ms. Jones has a question.
Yes, ma'am.
I've got a question. So you said that the section, it's already too late because they actually would have them kidnap them or whatever before you get this. What would be your fix to that, if there was one?
Honestly, and in my experience working with parents that deal with this issue, the simple, most cost-effective solution is to have law enforcement mitigate the situation out in the field.
What does that mean?
When they mitigate the situation, they look at everything that's being presented at that scene. Is it hostile? Is it non-hostile? Right? If it's non-hostile and the dad has a valid judicial court order, why are we restricting their fundamental right to their child? And so with this, you're talking about enticing or persuading the child. And that's what this bill goes over. And it says to leave the state. So if a parent picks up their child and moves to New York, now the father has a hard time trying to enforce this order, much less enforce it here than in New York, because there's no jurisdiction. If you go into the history about interference with child custody, the reason it's a felony is because when it was adopted before the UCCJEA came out, the federal law. And so the UCCJEA, Uniform Child Custody Enforcement Jurisdiction Act, sorry, I ran over here. It was legislated after, I'm sorry, the history. It was legislated after the whole issue. Law enforcement didn't want to get involved with these issues, so they kept saying it was a civil matter.
So most times when something like that happens, when it's a child custody issue, law enforcement comes out there and they say, hey, you got to go to civil court. This is a civil matter, right? So I understand that, but I think that it's not always easily ascertainable what's happening at the scene, right? Mm-hmm. For example, if it's a domestic violence situation, then it could appear from the outside looking in like it's not hostile when I just got beat, right? And I'm afraid to say anything. And so when the police are out there, I don't say anything. So I think that's hard to figure out for police. But what I'm trying to figure out from you is, are you saying, I don't like this? I know you're neutral, but I don't like this because it doesn't allow the police to do something at that moment. And I think I think X is the remedy. Can you give us a remedy that you think would work?
Again, I believe when you mitigate the situation, we all have the presumption that we're innocent, and it's even in the family code. And if you look deep into the family code, interference with child custody is domestic violence under the title. Under the title it's under, there's a presumption there that it's domestic violence. So while we're trying to protect victims of domestic violence, it's also domestic violence to keep or retain the child.
And let me be clear, part of my practice is that I practice family law. Mm-hmm. And parental alienation is bad, whether parents realize it or not. Keeping your child from one of their parents, it's going to manifest itself eventually. The child might not be able to figure it out when the child is younger, but when they get older, trust me, your child's going to have issues. I was just trying to figure out what your fix is, and it seems to me you're saying that officers should be able to do more at the moment in time that they're called out, and that's your fix.
Well, the government code, the family code has a specific statute that says every court order must have, the legal, any peace officer of the state may use reasonable efforts. Reasonable efforts, and we talked to the Senate yesterday about contempt orders. Reasonable efforts are trying to mitigate the situation in the best interest of the child. And so while someone has claims of domestic violence, there are legal remedies they can use. They can use, and Harris County, I'm very familiar with Harris County. There's AVDA, there's other resources out there in which they can use to obtain the correct mechanism to take or retain the child legally.
So I think you answered my question. Thank you. And I would like to thank you for bringing up AVDA, which is Aid to Victims of Domestic Abuse. It's one of the organizations that I believe very strongly in. But thank you. I think you answered my question.
Thank you.
Thank you. Mr. Cook?
I just want to confirm, what part of this bill do you not like? I don't think this bill says what you're saying it says.
If I can read it, an offense under subsection B is a Class C misdemeanor punishable by a fine of $500. Right now, it's a felony. It's a felony because when you take a child out of state, that's an issue.
But that's the part that you keep saying out of state. It's not required that it be out of state.
It says at the bottom,
under this bill.
It says number 2, entices or persuades. I have the bill here if I can show you.
I've got it right in front of me.
It says number 2, enticed or persuades the child to leave the state.
What section?
Right above section 2. But that brings an important question. What about for people in state when they persuade or entice the child to leave the custody of the parent here in the state of Texas, whether it's Dallas, Houston, Fort Worth? I understand removing the felony when children are being taken over crossing the lines, I think the safeguards the constitutional safeguards to protect the child, and you have a legal remedy in civil court and you have a legal remedy in criminal court. And your civil court's not going to go pull the other parent from New York to bring the child back for a $500 misdemeanor. So you need that felony bite. But again, if parents like myself are having a hard time because the other parent is retaining the child or taking the child in violation of the court order, this right here.
The point I'm making is that you can, you're talking about the punishment, but I'm talking about the crime itself. It does not require that the child be taken out of the state. What you're talking about is the punishment level goes up if the child is taken out of state, correct?
Well-
That's the point you're making, is that based on the way the bill is written, is that if the child goes out of state and it's on the first occasion, it's not a state jail felony like it is currently. That's the point you're making.
Currently, it's a felony.
That's what I just said.
Yes, sir.
Okay, thank you.
Okay, any other questions? Okay. Thank you for being here.
And I'm sorry, I forgot my shirt and I was running late and there was a car accident.
You look great. Anyone else here to testify for, against, or on Senate Bill 2794? If not, Representative Dutton to close.
Thank you, Mr. Chairman and members. Let me just address two things, which the witness brought up. The witness that just left talked about out of state. I'm not sure what bill he was looking at because this bill doesn't have anything to do with out of state. I'm not sure what he was referencing, but the bill clearly states that it's about interfering with child custody by the non-custodial parent. And secondly, I would just call attention to the fact that under Section 2503 of the Penal Code, it reads that the subsection doesn't apply if the person was entitled to possession or access of the child and was fleeing the commission or attempted commission of family violence. That's already in the law. And so I'm not sure what the other witness was referencing either, because the family violence exception is already there.
Any other questions for Mr. Dutton? Ms. Jones?
Can you cite that section, please? About
Section
the one that
25
talks about the family violence.
Section 2503, section C2.
You said that's all, you said that.
That's
that
already
this
in the
bit-
law.
Okay.
Yeah. Yeah, C-22. It's in the law.
Okay, thank you.
Yeah.
Okay. Thank you very much.
Thank you,
Ms.
Mr.
Dutton,
Chairman, members.
if there's nothing else, the chair will leave House Bill 2794 pending. Mr. Harris, let me get